Welcome. This presentation is part 2 of the history of law and medicine, which took place in France, Scandinavia, Germany, and England. I am Dr. Sandbar, a physician and an attorney. France had an early start among European nations in the cultivation of a medical legal system. From 1570 to 1692 AD, France enacted laws that favored the development of legal medicine as an academic discipline. By 1690, medical legal offices became corrupt, and progress in legal medicine actually regressed, not to start on a forward march again until after the French Revolution in the next century. The term legal medicine is derived from French médecine légale. It is considered to be the field of study and accumulation of materials that deal with the application of medical knowledge to the administration of justice. Forensic science is a broader term than the legal medicine. The adjective forensic encompasses a group of subspecialties in science and medicine, all of which convey the fundamental concepts of methods, both scientifically valid and legally admissible for the presentation of evidence in courts of law. For 100 years, from 1620 to 1720 AD, a serious topic of conversation in both medical and medical legal circles was whether a woman could be impregnated by the devil or in a dream. During that period, a French judge legitimized an infant in a case in which the husband had been separated for 4 years from the mother, on the grounds that the child owed its paternity to a dream. This picture is that of Popo Bawa, the name of an evil spirit or shitani that impregnated women. The evil spirit is believed by the residents of Zanzibar to have first appeared on the Tanzanian island of Pemba. The highest French medical legal authorities advocated the belief in ghosts, witches, and possession by the devil. They united with the clergy until 1752 in denouncing all disbelievers in those precepts as heretics and atheists. Until 1726, it was taught in France that in the presence of the murderer, his victims' wounds would open their congealed mouths and bleed afresh. Courts would accept the testimony of medical experts as to this miraculous bleeding of the corpse. Now let us turn to the Scandinavian countries. It is of interest that American law dates back to Vikings' Dane law. The Old Norse term Viking describes a person who sails away from his home to raid, trade, and explore. The Vikings were originally from Scandinavia, presently Denmark, Sweden, and Norway. Scandinavian pirates and traders impacted greatly the history and culture of Northern Europe. Beginning in the 8th century AD, the Vikings terrorized continental European coastlines with raids. The Norwegians raided Scotland and they founded Iceland. The Swedes raided the Baltic and Russia. Some of the Vikings were Danes from Denmark. The Proto-Norman Vikings settled their conquests and cultivated land. Another group, the Normans, settled in Normandy in northern France. In the 4th century AD, the Romans left England, and due to lack of Roman knowledge and expertise by British people, the sewage and heating systems fell into disrepair. Subsequently, the Saxons and other people invaded Britain, which was then separate from Scotland, Ireland, and Wales. Before the Norman conquest of 1066 AD, disputes in lower courts were settled with Anglo-Saxon law, but no standard or common rules were used. In 1066, the Normans invaded England and established the Danelaw instead of the Anglo-Saxon law. The Norman kings considered themselves to be the head of the court. They viewed the justice system as a political power tool to increase their wealth and control. The courts were regarded as servants of some economic or social interest. After the Norman invasion, common law was started in England by William the Conqueror. To gain control of the whole country, he set up the King's Court, called Curia Regis, and appointed judges who traveled around the country to settle disputes brought to them by the nobility. The English judges decided cases based on local customs and old laws from the areas they visited, mainly based on Scandinavian, Danish law, and folk law. By 1250 AD, all the customs and laws in England were combined and developed to form a system of common law or case law. Common law was made common to the whole country by Henry II. Its key features were the jury and courts of record, which were in place in the shire courts and royal courts. Common law was not law designed to protect only ordinary persons without rank or title, that is, commoners. It was applied generally to all people. Let us now turn to Germany. In the 5th century AD, the Germanic and Slavic peoples took over Western Europe. They instituted a system of indemnity in lieu of the primitive system of personal vendetta. The person responsible for the injury would pay an amount to the injured party or, in the case of death, to the relative. The payment varied with the severity of the wound. The wounds in the code were classified, and experts testified as to the damages. The Visigothic and Bavarian codes noted injury to pregnant women, to the child in utero, poisoning of prisoners, and penalties of negligent doctors if the patient died. In 1507, a comprehensive penal code was established in Germany that called for proof of cause in all violent deaths. The law allowed opening of bodies and represented progress toward the practice of medical legal autopsies and the development of legal medicine as a separate professional discipline. That became a subject for special instruction in the 17th century and early 18th century. Designated professorial chairs in legal medicine were created in German universities. Around that time, The earliest applications of medical observations were designed solely to aid justice. In Germany, legal medicine was not treated as being just a theoretical pursuit. It was brought into the courtroom. For example, the hydrostatic test was used in cases of suspected infanticide to determine whether a child had been born alive. In 1667, Schwammerdam in Germany claimed that the lungs of a newborn baby would float in water if the baby had actually breathed. That is, if it was not stillborn and had lived and subsequently died, either by natural causes or by homicide, the body would float in water. In 1681, Bernhard Gottlob Schreger, a German physician, used the hydrostatic test forensically and secured the acquittal of a girl who had been accused of murdering her illegitimate child. In 1553 AD, the Germanic Emperor Charles V published and proclaimed the Caroline Code, which clearly stated in its pertinent sections that expert medical testimony must be obtained for the guidance of the judges in cases of murder, wounding, poisoning, hanging, drowning, infanticide, and abortion, and in other circumstances involving injury to the person. Now let's turn to the Arabic and Persian canon of law and medicine. In 1025 AD, the canon of medicine was completed by Persian Muslim physician-philosopher Avicenna, or Ibn Sina. It is an encyclopedia of medicine in 5 books, written in Arabic and also called the Law of Medicine. It was translated at a later date into several languages, including English, French, and German. In 1100 AD, the Assises of Jerusalem asked the courts to order medical examinations. In the case of murder, the corpse had to be examined and a report made as to what had been found, the location of the injuries, and the likely mechanism that had caused the injury or death. Avicenna was an extraordinarily gifted and prolific author of about 450 publications. He also described practical and scientific theories about psychology and mental illness. For centuries, the Arabic canon of medicine was exceedingly famous and influential medical authority. It set standards in Middle East and Europe and served as the basis of traditional medicine. For example, when testing new medicines, Avicenna proposed the following: the medicine must be pure and contain nothing that would reduce its quality. The investigator must test the drug on one simple disease without complications. The medicine should be tested on at least 2 distinct diseases to determine efficacy and avoid accidental benefit. The quality of the medicine must match the severity of the disease. The investigator must time the process carefully so that the action of the medicine is not confused with other confounding factors such as the natural healing process. The effect of the medicine must be consistent, with several trials showing the same results, thus ruling out any accidental effects. And finally, Avicenna said that the investigators must test the medicine on humans not animals, as it may work differently for both. Civil law was based on Roman law codes. It was applied in Italy and in most of the other European countries that were originally occupied by the Romans. It was a codified system which spelled out a series of written laws adopted by the jurisdiction. It was inquisitorial in nature and heavily dependent on written word. Civil law judges were academics, specially trained for their positions, and they acted as prosecutor, judge, and jury. In contrast, common law is an adversarial system in which the oral argument between the parties plays a much larger role. It is largely judge-made law. It may incorporate some statutory elements on specific issues, but even statutes are subject to judicial interpretation. Judges are chosen from the practicing bar and are usually not academics. The judges act as referees and instruct the jury. The jury makes the ultimate decision on the merits of the case. Common law is made by appellate judges who hear a disputed case on appeal. The decision by the appellate court becomes a binding precedent called stare decisis for future cases. However, higher appellate courts or future appellate courts of the same level can overturn or overrule a prior decision if circumstances changed or new information develops. Change is a constant element of the common law, although slow and irregular. Under the early common law, cases more or less were confined to one of three categories: property law, contract law, and criminal law. Tort law lagged behind for a little over a century. Civil law compensated the individual for personal wrongs. Thus, during the 13th century AD, doctors were essentially immune to suit for medical malpractice. But the 14th century AD was historically disastrous to Europe because of the Black Plague. Between 1346 and 1381, the Black or bubonic plague affected 50% of the population of Europe. 2/3 of the English population was wiped out by the epidemic. The loss of manpower was a major blow to the English economy. The people that survived the plague became as important as real property and personal property in the English economy. So, a physician's mistake that deprived the economy of a worker became important enough to be brought before the courts as medical malpractice lawsuits. Physicians suddenly lost their immunity for medical practice errors. Compounding the problem, there was no tort law governing injury to a personal interest. Physicians became strictly liable for medical errors and unfavorable outcomes, and they were prosecuted for medical malpractice under the criminal law for maim. Other offenses included assault and battery, sexual offenses, and false imprisonment. By 1364, it had become obvious that this was too draconian a remedy. To permit the filing of a civil case, the court resorted to two property terms which had been previously used in livestock cases. The first was trespass, which was trespass by force and arms, and that was charged for direct injury. The second was trespass on the case, which was charged for indirect injury. Consequently, civil cases against doctors were brought in royal courts and London city courts with alarming frequency, which is fully commensurate with the litigious present. Many of the physicians' problems stemmed from the practice of physicians to undertake the cure of the patient and not to merely treat the patient. The medieval patient equated cure with fee. No cure, no fee. So, when the early causes of action were looked at, one found that there were the following. In that was happened in the 14th century. Charging excessive fees was one cause of action. Keeping the fee despite a failure to cure. Exacerbating the original complaint. Medical neglect. Maiming and death. The courts dealt with these charges with a combination of fines to redress the financial losses of the patient and to punish the patient, the physician, as well as pay the fee. They were imprisoned. By 1375, the concept of fault and standard of care had been introduced, but the malpractice actions went on at an accelerated rate. In 1415, the London guilds established rules for mandatory consultation and a series of fines for not doing so. 2 years later, in 1417, the Surgeons' Guild introduced a compulsory malpractice insurance pool. The high rate of malpractice suits continued well into the 17th century. Interestingly, as a side note, indigent migrants and criminals were being shipped to North America as indentured servants as early as 1650, and the rate of voluntary migration to North America increased steadily thereafter. Part 3 of this series will deal with the American law and medicine. The indentured servants received freedom dues for their work. In contrast, slaves that were brought to North America were treated as property. They were bought, sold, and auctioned. The development of legal medicine in Europe was always academically turbulent and against the intellectual current of the times. In 1209, Pope Innocent III provided for appointment of doctors to the courts for the determination of wounds. In 1249, in Italy, Hugo de Lucca took his oath as a medical legal expert, and medical reports of the times showed that autopsies were performed to determine the cause of death. Legal medicine began to be promoted within formal educational circles in Europe in the 17th century. In 1650, for example, in Germany, Michaelis delivered lectures on legal medicine. By 1720, professorships concerning legal medicine were founded by the state. About 1830, Germany established the first known medical legal clinic in Vienna and the second one in Berlin in 1833. In 1794 in France, the first French professorial chair in legal medicine was established. French judges appointed medical experts to testify who were graduates in medicine, who attended lectures, and had passed an examination in legal medicine. In 1840, France established its first medical legal clinic. In 1803 in Great Britain, the first British chair of forensic medicine was established at the University of Edinburgh. Going a little back in time, Charlemagne, or Charles the Great, who was a medieval emperor who ruled much of Western Europe from 786 to 814. In 771 AD, Charlemagne became king of the Franks. That's a Germanic tribe in present-day Belgium, France, Luxembourg, the Netherlands, and Western Germany. He attempted to give some unity to the laws of the empire. There was recognition of the necessity of adducing all relevant evidence in judicial cases. There were articles discussing the direct intervention of physicians and instructions to judges to seek all relevant medical evidence, especially in cases involving questions of wounds, infanticide, suicide, rape, bestiality, and divorce on the grounds of impotence. The first book on legal medicine written in England was authored by Samuel Farr in 1788 and was entitled Elements of Medical Jurisprudence. The book was a succinct and compendious description of findings of the human body that were required for judgment by coroners and courts of law in cases involving divorce, rape, and murder, among others. The first British teacher of legal medicine was Andrew Duncan. He was a professor of physiology who gave a course of lectures on legal medicine and public health beginning in 1789. His son, Andrew Duncan Jr., became the first professor of legal medicine at the University of Edinburgh, where the first chair in legal medicine in the English-speaking world was established. In the 19th century, Alfred Taylor, professor of medical jurisprudence at Guy's Hospital Medical School, wrote the book entitled Principles and Practice of Medical Jurisprudence. And in 1892, lectures were introduced in the law departments to fully prepare judges who would be qualified in legal medicine. In 1887, forensic science was largely a function of the medical profession and was most frequently referred to as medical jurisprudence or legal medicine. An accurate understanding of fingerprint and trace evidence was still in the future, but a few adventurous physicians versed in anatomy, pharmacy, and microscopy were beginning to use their skills in the study of unexplained sudden death. At first, this new field grew most vigorously on the European continent. The British Association in Forensic Medicine, ABFM, was established in 1950. Later, the British Academy of Forensic Sciences was created in 1960. I thank you and hope that you will listen to Part 3, which deals with the history of American law and medicine.